I thank the chairman for recognizing me. Mr. Chairman, nearly 25 years ago, President Ronald Reagan was given the option of signing what was at that time a little-known international treaty promising to bring the world's countries together to seamlessly and equitably manage the vast expanses of ocean covering the earth. That accord, all 17 parts, 320 articles, and 9 annexes to it, was known as the United Nations Convention of the Law of the Sea. It was presented to the President as a key national security imperative, an important economic opportunity, and a powerful message of cooperation and trust to send to our current and future friends around the globe. But, Mr. Chairman, it didn't take President Reagan more than a few days to separate the rhetoric from the reality. He rightly interpreted the Law of the Sea Treaty, LOST, as a direct affront to American sovereignty and envisioned, precisely as it turned out, that it might someday be used as a tool by foreign governments to exercise direct authority over American interest, activities, and industries. President Reagan not only refused to sign the treaty, he fired the staffers that were responsible for negotiating it in the first place. More than a generation later, there's talk in the U.S. Senate that they may dust off this stale treaty once again and bring it to a vote. Before it does, I believe this House has an obligation to take a close look at one element of this accord which will impact the way American companies invest in new technology. It will impede their ability to produce new energy and has long-range implications. Mr. Chairman, the amendment I have at the desk tonight would ensure that none of the funds spent in the state and foreign operations budget are used to support what's called the International Seabed Authority. It's a semi-autonomous, unelected body of the United Nations with authority to directly levy taxes and fines against American operators with or without their approval. Worse still, it would have the power to force a direct transfer of minerals and technology rights from the American companies that develop them to any competitor it sees fit. The treaty's collision course with autonomous American government is obvious, Mr. Chairman. The Seabed Authority is not only an obvious and very direct example of a UN effort to raise revenue without the input of the United States government, but the authority would also greatly disincentivize private investment to offshore energy exploration, which in our current energy climate is something this Congress should be working to avoid at all costs. We need all the energy we can get where we find it, submitting ourselves to an unelected, unaccountable international ocean bureaucracy when it comes to distributing what American companies rightly explore doesn't strike me as the thing to do 25 years ago or today. Tonight, Mr. Chairman, I've come to the floor to ask my colleagues to consider the implications of ceding unprecedented authority to an agency of the UN without proper oversight, without legitimate safeguards, and without a whole lot of concern about the economic and security well-being of the United States. I urge adoption, Mr. Chairman, and reserve the balance of my time.
Gentleman reserves the balance of his time.